One has absolutely nothing to do with the other. The fact is, a revocable living trust is going to avoid probate. A last will and testament takes it through probate, regardless of what the estate tax situation is. Hi, Jeff Marsocci, the Plain English Attorney, and welcome to the video. Today we're going to go through a whole bunch of questions about estate planning to get you some kind of bite-sized nuggets of what is really going on with estate planning. It's the simple questions that people are usually asking when they're approaching estate planning for the very first time, and they don't know really where to go. So let's go ahead and this is going to be taken from a very good book that's out there called The Living Trust by Henry W. Apps III. He has the Appendix G, which just has these questions. Now, I'm going to ask a lot of these questions. I'm going to throw in a few of my own, but the answers are all going to be mine. If you really want to go through and get a very, very thorough understanding of revocable living trusts and how they work, you're going to have to ignore the tax numbers because I think the latest edition was like 2003 or 2004, but it's still very relevant. And it's, again, The Living Trust by Henry W. Apps III. If you want a much more basic understanding, just getting right to the point, there's my book, Estate Planning Basics, and we'll have a link in the description. So for the first question, what happens if I die without a will? Well, the fact is, you've got a will, whether you know it or not, because the state has a plan for what happens if you pass on and you don't have your own written will with here are the instructions and here's who I want to be the executor. All that stuff is laid out for you if you don't want to put it in place. Problem is, it's not really customized at all. They just assume that your closest living relatives are the ones you want administering your estate, and you want them to receive your estate. And if it's, okay, well, it's a spouse, okay, they're kind of first in line. They still have to go through the probate process and get approved by the court and all this other stuff. But then, well, I've got 3 kids. So if your spouse goes before you do, and or you're single and divorced and you've got 3 kids, they're all in line to be co-executors or co-administrators. It's just a mess at that point, but that's the default. A lot of times I have clients say, yeah, I want my closest living relatives to get everything equally, but they have very specific people that they want to be in charge of handling that probate process. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Let's see. How are distributions different if I have a will versus a revocable living trust? Well, the thing is, the distributions have to go through the probate court process if you have a will or you don't. And the court has to administer it, and things get distributed based on the court's accounting and having things released, and it all has to be signed off and very formalized, which again means there's a lot of added potential costs there because it's in probate. If it's with the revocable living trust, yeah, you have to keep records, but it doesn't have to be with the formality of court, and your trustee can just go ahead and distribute them to you. This is a good one. Why didn't my attorney tell me about a living trust? Well, I'm seeing more attorneys these days at least reference a revocable living trust. But still, if clients call up and say, yeah, I need to get my will done, they go, oh, sure. They go ahead and they do a will, which means it's going to end up in probate, which means the lawyer gets to handle the probate work, which ends up being a lot more expensive than if it's being administered through a revocable living trust. So why aren't attorneys talking that much about revocable living trusts? Two potential reasons. One, they don't really know and understand it because it's not what they do every day like I do. I am a planning attorney. I do estate planning. I'm also a certified Medicaid planner. So this is the stuff that I do in and out all day long. This is what I do. If they're just doing divorces and say, well, yeah, I can make a little money. I'm not going to say on the side, it's still their law firm. I can make a little extra money for the firm if I just do those simple documents like wills and whatnot. So they don't know. Then there are the estate attorneys that handle probate, and that's where they make the vast majority of their money. Well, why tell somebody, oh yeah, here's how you can avoid having your estate pay me a lot of money in the future? Kind of that economic self-interest. Thing is, I really got into doing estate planning because I wanted to have my people avoid things like my grandmother had to go through, which was a probate for my grandfather's estate. And it took months and it was expensive, and she just didn't want anything to do with that horrible process, but she was kind of stuck in it because she was always told, oh yeah, do a will. So do I do wills in my practice? Well, of course I do if somebody really wants it, but they're always going to get informed about, here's what a revocable living trust is. Part of our whole pre-appointment process is we give you a copy of the book, Estate Planning Basics. It's really, I've been told it's a booklet. It's 70 pages, a couple of blank pages in there too. It's not very heavy reading, but it gets to the points of here's what a will is versus a trust. Here's what probate is. Here are some of the downsides of probate. Here's what a revocable living trust does to avoid all that. And it does it very quickly and very easily. So if my clients go through that and they go, yeah, probate's not a big deal to me, I don't see it a big thing, let's go ahead and do wills. Okay, that's fine, but they've made an informed choice. So there are a lot of attorneys that just don't talk about it, and it's either because they don't know or they're looking for money in the future. All right, so what's another question that we've got here? Do I need to tell my attorney that I'm doing a living trust like with somebody else, or I'm doing a new will? No, you don't have to tell the old attorneys, because in particular, if it's a will-based plan, they set you up with wills. Some of the first language right at the very top is, I hereby declare that this is my last will and testament, revoking all previous wills or all previous documents. Some language like that. Basically, one of the first things your new will does is it revokes your old will. That's standard kind of across the board. And even if it didn't say that, most state law says, look, if you've got two wills and one was later, that's the one that you go with. So you just check the dates. And so it always goes with the latest version of the will. You don't have to tell those attorneys that. What you need to make sure is that the people you have handling things like your trustee of the revocable trust and the executor of the pour-over will, that they know that this is the correct version, so that the other firm gets word, oh, they passed on. Well, we've got their original will. Well, no, wait a minute. Here's a new one, and it's done and combined with a revocable living trust. So, no, you don't have to tell the old attorneys that you've got a new will and a new trust. All right. What other questions do we have? This is a good one, and it used to be a lot more of a big tax deal. My accountant said that I have less than $1 million, or in today's dollars, I had less than $13 million. I don't need a trust. Okay, I used to hear that all the time. That's like telling someone, oh, you don't need to change the oil in your car. Your gas tank is full. One has absolutely nothing to do with the other. The fact is, a revocable living trust is going to avoid probate. A last will and testament takes it through probate, regardless of what the estate tax situation is. If you have less than 13 million federally, you don't have to worry about estate taxes. Your state may have a lower threshold, but federally, you don't have to worry about estate taxes unless your estate is above that limit, with or without a revocable living trust. Is there a way that it helps with taxes with a married couple? Absolutely, because it doubles it up. So it could be up to about 26 million federally in 2023. About. So, yeah, one has to do with taxes. The other has to do with the administration and avoiding probate. Just because, oh, it's not going to save anything on estate taxes, why do it? Well, the reason is because it costs a lot and it's time-consuming and frustrating to take an estate through the probate court process, and the revocable trust can avoid that. Let's check another question. Is an attorney required to charge statutory fees regarding probate? Well, okay. This is not a very strict question because in all the states that I've seen, there is a mechanism for exceeding whatever the statutory percentage of the estate is if it's warranted. Some states, and then probably from judge to judge or North Carolina, clerk to clerk, they may have a bit more leniency or might be pretty strict on limiting attorney's fees for helping out in handling probate. Now, the way North Carolina does it, essentially it's assumed it's 5%, but it's not a mandate. California has statutory fees of 5%. How do I know this? Well, because we were working with an estate. There was an account that was in California, and under the state's rules, they made us go through that California court and therefore had to have a California licensed attorney handle ancillary probate. It was almost $700,000 in that account. For doing paperwork for that one account, that attorney got 35 grand. Statutory fees. They didn't argue for more, but they got that 5%. All right. How can attorneys justify their exorbitant fees? Because everybody does it. And that's what's usual and customary for that type of work. And believe me, there's some work that has to go into probate. It's very exacting. There's lots of forms. You have to put together a lot of paperwork, a lot of justification, and you've got to prove a lot of things to the court. The thing is, the process can be avoided for everything that's inside a revocable living trust. So why not avoid it for all that? This is especially true if what the attorney is going to charge is based on what assets are in probate. If you keep it out of probate with a revocable living trust, then the fees aren't going to be applied to that through the probate court. All right, you've kept it so that it's the fees are lower because there's not that much that's in probate. How do we justify it? Well, look, I don't have a problem with attorneys making the kind of money that they do handling probate. Where I've got an issue is when they're telling their clients at the planning stage, oh, probate's no big deal. Don't worry about it. It's not that much of a problem. Yeah, go ahead and do wills. Oh, you don't need a trust to avoid probate. Oh, no, don't worry about that stuff. Don't listen to what that plain English attorney did on his video. You're fine with the will. No, that's where I've got a problem. Because you can set things up to avoid probate. And a revocable living trust can be very beneficial for even smaller estates. We had one probate case where the woman had about 12 different bank accounts spread out amongst a whole lot of banks because she didn't really trust that banks weren't going to go under. And, well, occasionally that does happen. So she spread things out. Thing is, it was a little over $100,000. And it definitely ended up costing about, we were getting close to 10%, just because there was so much work involved in justifying everything and collecting all the assets spread out among 12 different banks. Well, what if it were $1 million at one bank? Well, then it actually probably would have ended up costing a lot less because it's just the one asset. And there isn't as much work that has to go into it. So, yeah, I don't have a problem with attorneys that are doing probate work getting paid for what they do. It's the planning phase when they're telling clients, don't worry about it. That's where I've got more of an issue. All right, we got another question. What happens with assets that are outside my living trust and I pass on? So if there's no pay on death beneficiary, if it's just an account that's in your name and it never got retitled into the trust, this is what we call trust funding. Well, then that has to go through probate. Okay, well, the living trust is designed to avoid probate, but you got to think of it like a suitcase. A Kevlar bulletproof suitcase. But you can't complain if you didn't pack the shirts that you wanted inside the suitcase and they ended up having to be shipped to your vacation location separate. Okay, so yeah, it's about funding the trust the right way. Well, how does that work with the will that goes along with the revocable trust? Now, I haven't seen this as much in recent years where you've got your revocable living trust. Here's who the beneficiaries are. They get what at what age. What if this person passes on? And all that stuff is all laid out in the trust. And I've seen some attorneys put exactly the same stuff in the will. Well, why would you do that? A will that accompanies a revocable living trust should just state, if anything ends up in probate, it goes to the trust to be distributed. So yeah, those assets have to go through that process of probate, but then it just goes into the trust to be distributed along with everything else. Well, why is that important? Well, it's a privacy issue. Because one of the big benefits of avoiding probate that you get with the revocable trust as opposed to the will is, in the end, people don't really know who your beneficiaries are. It's in the trust, which is private. If you lay all of that stuff out in the will, suddenly names, ages, and addresses of your beneficiaries have to be put on file. They have to get beneficiary notifications through the court. They have to sign and acknowledge stuff to close out the estate. It's adding to the paperwork, and the marketing people see that they're beneficiaries. So even if it's small stuff, if it's going to the trust, the only one who has to sign off on receiving that property is the trustee. So only the name and address of the trustee is listed in those court filings, which usually means that the marketing people who go through all that stuff to try to sell you brand new cars and other stuff with all the money you're getting through the estate, they tend to leave the trustees alone. So it's actually a privacy thing. All right, let's check out another question. Can probate be avoided using joint tenancy? Yes, it can, but this is what I call duct tape solutions. Yeah, it's good for like one shot. You know, if the door is falling off your car and you're going to duct tape it shut because you just need to drive it to the car repair place to get it actually fixed. All right, that's what joint property is when you're talking about avoiding probate. What happens if both of you pass on at the same time? Okay, the whole thing goes into probate. Oh, well, how often is that going to happen? Well, it happens more than you think, especially if it's a couple, their spouses, and they're driving around together. They could get into a car accident and die. That means that joint property stuff, the right of survivorship, doesn't mean anything. it also has a lot of downsides and drawbacks, especially if it's not a spouse. Maybe it's, oh, well, I'm just going to put my kids on my accounts and whatnot. One of them gets into trouble. They get sued. They get into a car accident and injure someone else. Well, now that account is on the table for the lawsuit. What if it's a house? Okay, there's some vulnerability there to that lawsuit. There are ways to use joint property, specifically with things like houses if you're doing Medicaid planning, but that's a balancing of things. Just to avoid probate? No, that's, again, it's duct tape. Does it work? Yeah. Should you do it? It's not going to go very far in your plan. The other thing is, what if it's kids and you want age limits? You want contingencies. You want a trustee to oversee things in case they're younger. Doesn't work with any of that. All right, so what's another good question that we can take a look at? Okay, yeah, we'll skip the community property stuff, only because that only applies to a certain number of states, and it's just a tax thing for capital gains taxes. Is there any problem with transferring assets held in joint tenancy into the living trust? This is where we're talking about a couple that's married or not, and they're moving their joint asset into the revocable living trust. Well, at that point, it's fine because you're both the trustors and trustees and the beneficiaries of the trust. It's still joint. What if it's joint with someone other than a spouse who's going to be on a plan? Or let's take something that's kind of in between. Yes, we're spouses. Maybe it's a second marriage a little bit later in life. We've each got our own plans and our own stuff. And it's a house. And we own it jointly with the right of survivorship. How do we handle that? You move 50% into each trust, and you have provisions in the trust to make sure that the spouse is going to be able to live there for the rest of their lives or have some control over it. And when it eventually goes down to the next generation, when the second person passes on, everything that you want is already kind of laid out. So you can have the house there to survive and go to that surviving person and let them use it without necessarily giving it to them. So you can set it up inside two revocable trusts with each of your plans, but still have that one house divided into it. So that'll avoid probate for both passings. All right, what if it's with a child? Well, then it's splitting it so that your share goes into your trust and your child handles whatever they're going to do. So, yeah, there's really no problem, especially if it's joint and it's a couple and it's a joint trust. Just go ahead and transfer it in. That's it's going to be fine. All right, let's go for another question. Yeah, regarding the living trust, this is a good one. Where did this new idea of the living trust come from, and how long has the living trust been used? Okay, we're talking about going back to medieval times when trusts were set up so that the king couldn't confiscate land or other noblemen get hold of your land because of trumped up charges and crimes, and okay, we're going to execute it and then we're going to confiscate all of your property. Well, look, if it was put into a trust, the courts, even back then in medieval times, said, well, the king can't confiscate it because the person who committed the crime, whether they did or not, didn't own the land, so it can stay within the family through this trust. That concept came over to the New World, and the very first revocable living trust done in the colonies, not even the United States, in the colonies, was drafted by this country lawyer out of Virginia named Patrick Henry. And he put this together for the then Lieutenant Governor of the colony of Virginia. So it's been around since before we were actually the United States. So saying this is a new concept is a little bit ridiculous. It's just a lot more widespread as more and more people are getting information on revocable living trusts as a way to avoid probate and handle an estate the right way. All right, so let's check out another question, and then we'll see about wrapping this up. We're probably going to do several parts of this because there are a lot of good questions that could have some pretty good detailed answers. When will Congress take away the living trust? Well, here's the thing. This is a concept that has been rooted in law for hundreds and hundreds of years. Like I said, even predating the United States of America. So there's no real reason for Congress to take away a concept of avoiding probate when Congress, they would be more concerned on the tax angle. And that's not revocable living trusts. The other thing is a lot of very wealthy people have a lot of influence in Congress because they donate to elections. They don't want the revocable living trust to go away. So there's really no government reason to take it away. And the people with a lot of money and influence also don't want it to go away. So I don't see it going away anytime soon. There's just no money in taking it away. The only people who want it are the probate attorneys, but you know what? There are a ton of people who are dying with either wills or no plan at all, who need the help of the attorney. They've got all the business they need. They don't need your particular business if you're going to do a revocable living trust to avoid probate. All right, let's do one more question, and then we'll call it for this video. Right. Does my advisor need to be an attorney? So, okay, this is going to take several minutes, but this is a good explanation. The way I work with a lot of financial advisors, particularly through a network that was originally established by Henry Apps, who wrote the Living Trust, there are very specific outlines of duties and stuff. So doing a living trust all the way through, it's not all necessary that an attorney be the person driving the process. So I work with a lot of advisors where we're sharing some of these duties. And in fact, the way I prefer to do it so that I'm maintaining, quote, supervision in a lot of these cases is I'm actually, quote, subcontracting with the advisor. Not in all the cases, but typically the concept of the revocable living trust is being introduced to the clients by the advisor. They're the ones who are helping them out with their finances. Look, we need to look to what's going to happen for the next generation. You need to have a plan in place. You need to have an estate plan. A revocable living trust is a good way to avoid probate in that transfer to the next generation. Here's some information. Now, the thing is, when I work with these clients, sometimes I'm the one running through it, but if I'm not, if it's the advisor handling it, part of what I do is I make my materials accessible to those clients so that they can see and understand stuff about the revocable living trust. Typically, they're getting a copy of my book, Estate Planning Basics, or there's also the audio book in PDF download version, which is also going to be linked in the description. They're going to get all of that stuff, so they're going to understand that. Then we do a summary meeting, typically after I talk with the clients, get information, put together a summary. In some cases, I'm getting the documents already put together on the legal end. And then they go through, typically they'll go through the summary with the advisor. So the advisor's making sure that everything's correct, but then they send it back to me. I send the documents, and now legally, most of their questions are going to be legal. I'm the one working with them, running through their questions, discussing what's going on. making sure that they understand what they're getting, and at the same time, whatever questions they've got. Sometimes these are quick meetings. Sometimes they get pretty involved and they've got very good questions. Fantastic. And then we'll go ahead and get the documents printed up and handle the signing, either with my office, or if the advisor knows what they're doing, they're handling the signing. And then we try to make sure we're getting a copy of the signed document, so we've got that for our files. So a lot of this stuff with putting together a revocable living trust does not need the attorney to be involved in every step, or even the law firm be involved in every single step. But there are legal things that we do have to take care of, and we do. So does your advisor need to be an attorney? Well, no, that's not what they do. But you do need to have an attorney involved in the process. All right, so let's call it for this particular installment. We got a lot more questions that we'll go to, and we'll do it in future videos. So I hope you got a lot of good information. As I mentioned, the book that I'm getting the questions out of is The Living Trust by Henry W. Apps III, but that's basically a 400-page book. There's my book, Estate Planning Basics, where we've got a link where you can get that either through Amazon, or there's the audio book with PDF download available through my Plain English Attorney products and courses. And I hope that you go ahead and take these basic questions, get some of your own, go ahead and list them in the comments. We'll add it to a future video, and I might even be able to just give you a quick short answer in the comments. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.